Hi everyone, my name is Delene Grant and welcome to part 10 of my presentation on Ontario Superior Court of Justice, Motion Record and Order. Okay, we're now at tab uh, L. I'm going through, and as I said, as I'm going through, you'll be familiar with some of the documents because we have already been through those other presentation. But I have to bring this forward because I'm addressing this tab here. I'm addressing this section here from the Superior Court of Justice, just to show you that I have proof and what happened and that this information is just false. It should be scrapped from the legal system, okay? Feel free to pause and read if I'm going too fast. I'm just going to summarize as I go along, okay? Thank you. So for tab L, it is email correspondence dated September 28, 2020, okay? L. Email correspondence dated September 28, 2020. Courtney Madison, Neymark Law, had already informed the defense X Morley Law without my consent that the examination for discovery would be adjourned and rescheduled. As you can recall, these two emails from Courtney Madison, okay? So on September 28, 2020, okay, the day before the examination for discovery, Courtney was trying to get me to cancel, okay? 2:19 p.m. after I spoke with her earlier, prior to 2 p.m. there, morning, afternoon there, she said here, I confirm I have recommended to you that we engage in settlement discussions and adjourn your discovery by 1 month. Okay? Then that's 2:19 p.m. Then the same day, Monday, September 28, 2020, at 3:19 p.m., she's gonna say, again, I would highly recommend that you accept my advice to put over the discovery 1 month and to focus on negotiating, right, a settlement in the interim. Now, I was at an appointment, at an examination, actually, appointment, right, and I came out when I got in my car. It was 3:50. By the time I left and got in my vehicle, it was 3:50. And when I opened my email, I realized this, and it says if she didn't hear from me by 3:45, they will cancel. Right? Courtney called me at 3:51. Yeah, 3:51. Oh, she knew to call me then, eh? Just thought of that. Anyway, as you can see, hence the letter, okay? Because again, she was corresponding with the defense, as you can see on the next slide. Thank you. At 3:50, when I got in my vehicle, that's when I was made aware that my lawyer, Courtney Madison, had cancelled the examination for discovery, which was for September 29, 2020. Okay, I saw the email that says it would have been cancelled at 3:45. So Courtney contacted me at 3:51. Okay, and while we're on the phone, I didn't realize that things were going on behind the scene, eh? Because here, from Amy Tibble, right? It says here, sent Monday, September 28, 2020 at 3:58 p.m. Courtney Madison, Neymark Law, and I were on the phone even up till after 4. Yeah. So this email, they were doing things behind the scene, you see, with and I did not know. You understand? So here, as you see, Amy copied in Courtney Madison, Neymark Law, and Joanna. Okay, Joanna is from Manulife, huh? And it says here, hi Joanna, from Amy Tibble, right? She said, hi Joanna, the discovery for tomorrow will be adjourned and rescheduled. The parties, I did not know. So he said, the parties, huh? The parties are contemplating pre-discovery mediation, and as well, we'll keep you in the loop. Okay, so while on the phone, my lawyer was communicating with the defense. But I guess Samantha Bray, Denise Coy, whoever, what they were doing their stuff. Please feel free to review. Thank you. I've enlarged it for you, okay? And as again, breach of contract. This was included. Name or clause cancelled. Cancelled, as you were made aware, cancelled without my consent. And again, client supposed to make the critical decision, right? As a matter of fact, they were the client because they weren't asking me any question. They were doing their own thing. So I guess that's why they had the right to cancel. My signature on the contract, but they had the right to cancel. Eh? Wow. There it is. Client, you see, will make all critical decisions. We went through this already. Thank you. Okay. And here it's on the contract. I brought it forward again. One of several breaches. Okay. Client to make all critical decisions. Courtney Madison name or clause cancelled the examination for discovery on September 29, 2020. Her final reason for cancelling was that it should have been a mediation. Did she just realize that 1 year and 2 months later? We went through this. Be free to read again. As I said, I brought these forward again because I'm addressing the tabs, okay, from the Ontario Superior Court. In here, it says about 28, 2020. The same thing is the same thing here. 2:03 p.m. It's clearer here. I have highlighted here, but it's clearer here. It says that I have given thought to our conversation this afternoon in regards to canceling my examination for discovery scheduled for tomorrow, September 29. I sent this to Courtney. Yes, I sent this to Courtney. And it's because we had a telephone conversation, right? So that's why I was thinking about what she said. And she said that it should have a mediation 1 month, right? From the date. 1 month from the date. As a matter of fact, that's what it says. 1 month from the date. So the mediation would have been, say, October 28th. Okay. And I was not in agreement. Okay. Please feel free to review. Thank you. And Courtney responded, and Courtney was saying that she think I should adjourn, right? Adjourn the discovery, examination for discovery, right? By 1 month. Still not an agreement. She said at 2:19 p.m. and also at 3:19 p.m. She did say put over discovery 1 month, right? And if you didn't hear from me, she was going to cancel, as you can see here, and she did cancel. Okay, and no, we did not have a discovery. We did not have any mediation, no information at all from Courtney in October and November. Please feel free to review. Thank you. Instead, as you were made aware that Sanjay Mistry called me, and he called me about the motor vehicle accident, and that's why he was able to speak with Courtney and all that, and a meeting was scheduled for December 11, 2020 at 11 a.m. The meeting that's supposed to be September 25th at 2 p.m. was now going to be December 11th, 2020, because I had to say something. Yeah, please feel free to review again. Thanks. Now we are at M. Tab M. Email correspondence dated December 8, 2020 with attached mediation confirmation and agreement. M. Email correspondence dated December 8, 2020 with attached mediation confirmation agreement. And I said here, Courtney Madison Neymark Law had no intention of meeting with me, but instead to deliberately delay my cases again to frustrate. As soon as I inquired on November 30th, 2020 about the meeting, Courtney Madison contacted the defense and made arrangement for a mediation date to ensure that she was prepared for our meeting date in December 11, 2020. And I did show that to you, okay? It was part of the motion. Okay, this is the same thing I've extracted. Okay, as you can see here, this I brought forward for you, and it's from here Denise, right, reached out to Money Life and X Morley Law here, November 30, 2020 at 1:22 p.m. There it is. I've enlarged it. November 30, 2020, 1:22 p.m. Right? And then that's when Sunday Mystery is gonna email me same day at 3:21 p.m. after they got the date and everything set up there. They were Neymark Law was in communication with X Morley Law Firm. Wow. Should that have been that shouldn't happen, eh? Wow. Please feel free to review. Thank you. Retrieve for motion. Okay, says Tuesday, December 8, 2020. All right. When this person, maybe she's from Money Life, I guess, right? Had emailed Nancy Keating, right? Had emailed everyone, including Denise Coy. They're making the arrangements for the mediation scheduled for Thursday, January 21st, 2021. Okay, please feel free to review. Okay, retrieve from motion. Here it is. That's what I have to say. Where's my name? I have never seen this document before. So they, Courtney Madison, Joan Board, Courtney Madison, Neymark Law, Joan Board, Manufacturers Life Insurance, Amy Timble, X Morley Law. Okay. And then they make sure a meeting was scheduled. A mediation, that is, scheduled for Thursday, January 21st, 2021. Please feel free to review. Retrieve from motion. All right. This was dated December 7, 2020. Okay. Letter received via mail actually. Yeah, after the phone meeting with Courtney, right? After the phone meeting on December 11, 2020, the information is all wrong. Where's Industrial Alliance Insurance on a letter? So I was gonna only meet with Money Life. Okay, as you can see, Neymark Law. The letter is dated December 8 after they deliberated and set up time and everything, and then it's Grant versus Bell. And I went through this with you. This is so wrong. They're gonna have long-term disability, which is not Money Life, no. So as I said, this letter was already wrong. So no, I will not. They will no longer confuse situation. I already see them for what they are already. So no, I'm not taking it any further. See, they didn't even know how to do their thing. They're confused. Because in school, I know definitely that if I have Grant versus Bell and / Money Life, and I have date, the date supposed to correspond with the information above. Grant versus Bell supposed to be May 24, 2018, and Money Life supposed to be April 2nd, 2018. If so, although again, this information is wrong. So no, I declined the mediation. Okay. Meeting with Courtney. And you can recall the meeting with Courtney, right? Please feel free to read. She was saying further to our 1.5 hour call. She's making notes, eh? All right. But that call, my eyes were open, eh? But that call did it for me. I said, definitely not. Especially asking her questions about how much will I get? What is it? Then she's going to say, a number of years worked. Blah. It's like, give me a total. She's trying to break it down. And if you win your case, oh, I mean, if I win my case, you understand what I say? This lawyer, oh, no, 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 no. She did her own thing, so she knew definitely that I wasn't gonna win. Yeah, please feel free to review. Okay. And when I saw, as I said, when I saw the affidavit, that actually did it for me. It did it for me, right? My mind was made up. Things were missing. Things were included that should not have been. This was left out, as I indicated to you. Things, my medical record for the distorted medical record for the Minister of Health was left out. I'm not gonna go back through stuff. We already dealt with it. Just letting you know. Just letting you know that these were not included. Especially like this is for the motor vehicle accident. I have spurs and all that. Please feel free to review. Thank you. After I saw the affidavit, I had nothing more to say to this lawyer named Mark Law. Okay, please feel free to read. Okay, we went through this already on my presentation with Mark Law. Okay, from Denise. They're trying to get a hold of me. Okay, for this is further to my recent voicemail left for you today and yesterday. Please let me know if you are still interested in having a meeting with Courtney this week. Nope. I just remain silent. No, nothing to say. December 17th, so this is from Courtney, and Courtney is saying Denise contacted you on Tuesday to confirm whether you wanted to meet, wanted a meeting on Thursday or Friday this week to discuss your case, having reviewed the affidavits of documents. I don't think you have responded to Denise's calls or emails. Nope. I was done. Too many breaches, and I have my proof that this lawyer from 2019 had breached their contract, and I just have to. I went through the nonsense. So no, this was enough. All right. Please feel free to review again if you wish. Thank you. Okay.